Hey there. Today I want to tell you about a really interesting case from Ontario. It's a case that we at the Canadian Constitution Foundation are intervening in, and it's about whether or not the executive, so our political leaders, can override laws passed by the legislature. That is something that is happening in Ontario right now with the Doug Ford government. The case is called Canada Christian College and Ontario Post-Secondary Quality Assessment Board and the King. And I can't wait to tell you all about it. If you're new here, welcome. My name is Christine and I'm the litigation director for the Canadian Constitution Foundation, a legal charity that fights for fundamental freedoms in Canada. I upload regular videos about our ongoing cases and about other interesting developments in constitutional law in Canada. So if that sounds like something you'd be interested in, please hit like and subscribe below. It really helps my videos out a lot. Also, please remember, nothing in my videos is legal advice. If you have your own legal question or problem, consult your own lawyer. So let me tell you about this case, Canada Christian College and Ontario. Now, you may have heard about the case because it has caused a bunch of political controversy. And the controversy is interesting for sure, but it's actually not what I care about or what makes this case so important in the long term. What I care about are the broader constitutional principles in this case. But I'm going to tell you about the controversy anyway, because hey, who doesn't like hearing about a little bit of drama? So the dispute in the case arose out of a decision by the Ontario legislature at Queen's Park to pass a law that allowed a school called Canada Christian College to call itself a university and give it the power to grant arts and science degrees. Now, Canada Christian College is run by a man named Charles McVety, who is a political ally of Premier Doug Ford. And Canada Christian College is considered controversial by many people. Now, I don't actually know much about the school specifically. I had to read up about it to learn about it, but I have also asked around. And even among Christian evangelical groups, I have a number of Christian evangelical friends, and I've asked them about the school. And what they say, they like to emphasize that it's actually not a very important player among evangelical communities in Ontario. But the president, McVety, has made very controversial and polarizing statements. So as a result of those statements, the media pays a lot of disproportionate attention, perhaps pays more attention, according to my friends, to the school than it perhaps deserves. And, you know, I do understand that perspective. That is pretty typical of how the mainstream media and legacy media treats these things, I guess. Anyway, that is not my view. I don't have much of a view on this college in particular, but that's part of what I have been told. And I've also researched some of these statements that McVety has said. And the things that have made McVety controversial in particular are, first, he's been very central in a number of campaigns against gay rights. And he has also made what are considered controversial statements about Islam. And I have looked up the statements. You can look them up too. I'm not going to repeat them here because I don't agree with those statements and I don't think that they are true. And I also think that they are hurtful statements. Another thing that has made Canada Christian College controversial is that it often hosts events put on by Rebel News, which is controversial itself among some people. I don't have a problem with them hosting these events, but of course, a lot of people do, and that has fueled in part some of the controversy. And there have also been questions raised about the financial dealings between the college and the president, McVety, and there have been some lawsuits about the financial dealings of the school. You can read about that as well. I don't know much about it other than what has been reported in the media. And lastly, there is the issue that McVety is a political ally of Doug Ford, and during Ford's leadership campaign, Canada Christian College either rented or donated space to Ford's leadership campaign, and that attracted controversy as well. The NDP alleged that the use of this space constituted an unreported in-kind donation, and that the college as a charity can't even make those types of donations. And if it had made that as a donation, it was not reported. So that's the list. That's the list of some of the controversies, a lot of different controversies around this college. Now, the college wanted to expand its degree granting authority and call itself a university instead of a college. And with Ford as premier and a political ally, the time was ripe for them to get that process started. So they asked for this change in the legislation. And the Minister of Training, Colleges and Universities asked the Post-Secondary Quality Education Assessment Board, which is a board that makes these decisions. The minister asked this board to provide him with advice and recommendations. So he had that process going, but then simultaneously he introduced legislation that would have made the college a university and given them this power to grant degrees. Because both of those processes were proceeding simultaneously, this is referred to as a hybrid process. And in December 2020, the Ontario legislature actually passed that legislation, allowing Canada Christian College to call itself a university and grant Bachelor of Science and Bachelor of Arts degrees. This was contained within a larger piece of economic legislation called the Better for People, Smarter for Business Act of 2020. And the legislation was passed with this provision related to Canada Christian College, and it received royal assent. And this all happened before that board that the minister had appointed to look into this, before they had issued any advice or recommendations. So during that time, the board was proceeding with their process, and they had commissioned a panel of one person to review the college's materials. And that person did make a recommendation for improvement of the college, and Canada Christian College addressed that concern. So obviously, once the legislation passed, this political controversy exploded because of that relationship between Ford and the president of the college, and because the long history of the college being unpopular in certain communities, and the president having been involved in some of these campaigns and making statements that offended a number of people. And the controversy is summed up by a number of different headlines by legacy media. For example, the Toronto Star ran the headline, "Doug Ford wants to give university status to a school run by a homophobic preacher," but that's only half the story. And then CBC News ran a story titled, "Controversial Bill Allowing Ford Supporters College to Grant New Degrees Passes." And in question period, former Liberal Premier Kathleen Wynne asked the Minister of Training and Colleges, to quote former Premier Wynne, why this government would extend the mandate of the most publicly and vocally homophobic man in Ontario. Why, in the name of all that is decent, would this minister validate the hateful, vicious, racist, and homophobic rhetoric of Charles McVety by extending the reach of his Canada Christian College? So that was the statement. So the Ford government appeared unable to stomach this controversy that they should have known was going to happen. But that is no surprise. The Ford government is very sensitive to controversy, and they do blow with the wind a little bit if something happens that seems politically unpopular. The Ford government will shift its position quite rapidly. There's many examples of this happening. So their response to this particular controversy was to put the brakes on the legislation that they had actually already passed. So in May of 2021, which was 5 months after the legislation had already passed and received royal assent, that board that the minister had created issued findings that Canada Christian College was not ready, to use their term, for the title of university or for expanded degree granting. Relying on this report from the board, the Minister of Training refused to proclaim into force that legislation that had already passed. And he made that refusal using something called a commencement provision in the legislation. And the commencement provision confers statutory discretion on the executive to bring validly enacted legislation into force. But the problem with this is that this commencement provision doesn't actually allow the minister to veto legislation that's already been passed. The executive can't override the will of the legislature this way. Even if the the Ford government subsequently regretted its decision to propose and pass this legislation giving Canada Christian College new powers to grant degrees and call itself a university. And if they regretted using their legislative majority to pass that law, the right and legal course of action would be to use the same legislative majority to repeal it. Ford could have done what he wanted to do easily. He could have just brought in a new piece of legislation. The problem with that is that it's very politically inconvenient, and it would look obviously as if he's responding to political controversy, and it probably would have caused a big problem with his political ally, Charles McVety, at Canada Christian College. But the political inconvenience of repealing the legislation is not a legal excuse. Allowing the Minister of Training to use powers he doesn't have to block a law in order to save political face, that's executive overreach. It intrudes on the power of the legislature to make laws. And the long-term consequences of giving a minister this type of veto power over properly enacted laws is profoundly undemocratic. The issue in the appeal, because Canada Christian College has appealed this, they are now going to the Ontario Court of Appeal, and we are intervening in support of the college, even notwithstanding all of those comments I made about the controversy of the college and my perspective on it. I think the college is right here that the executive doesn't have this authority. The issue in the appeal is the question of whether a commencement provision can authorize the executive or political leaders to never bring legislation or provisions into force. And commencement provisions grant the executive the power to bring into force legislation or provisions, but they don't give the legislative powers to the executive. They don't give the executive the power to de facto or in practice repeal legislation by never bringing it into force, unless that commencement provision has that express language in it, which this one didn't. A commencement provision like the one in this appeal only grants the executive the limited power to determine when to bring the law into force, not whether or not our political leaders can decide never to bring it into force at all. And this is really, really important, because these commencement provisions, even if you've maybe never heard that term used before, they are pervasive in Canadian law. They are present in over 400 statutes in Ontario laws and federal laws. And the court's decision in this case has potentially very wide-reaching implications across our country. The government's approach has the potential to empower the executive, so the cabinet and the premier or prime minister, to just actively refuse to bring legislation into force in whole or part, or in practice repeal legislation, and in doing so undermine the intention of the legislature. The purpose of a commencement provision doesn't extend to giving the executive the power to frustrate or defy the will of the legislature. As I said, that result would be profoundly undemocratic and could lead to all kinds of unforeseen consequences. Let's talk about what some of those consequences could be. First, imagine a scenario with a minority government. If commencement provisions mean what the Ford government says they're meaning here, a minority government could decline to bring into force legislation adopted by its political opponents in the legislature. Just imagine what the current federal minority government would look like if that were the case. In another scenario, if there's a change in government as a result of an election, the new government could use commencement provisions to undermine the legislative intent of the previous legislature without forcing them to actually go through the legislative process as the democratic process of making or repealing laws. They could just have the premier waltz in and veto, essentially, laws that had been passed by the previous legislature but had not been yet declared into force. Another scenario is if legislation is introduced by the government and then amended through the legislative process by opposition parties in committees or members of the governing party itself. Well, even after all those amendments, and we watched this all happen with, for example, C11, this amending process is very important in how laws are made. Well, if the commencement provisions are interpreted the way Ford, in this case, is saying they are, our political leaders, the executive, could in theory just bring into force the original provisions without accepting any of those amendments. So these are really serious and undemocratic consequences to interpreting commencement provisions as a veto power for the executive to undo legislation. By refusing to proclaim the legislation into force in the Canada Christian College case, the minister was appropriating power to himself that actually belonged to the legislature. While, Canada Christian College might not be popular, and there's a lot of political theater around this case creating a big spectacle, it's actually in cases like this where executive overreach is most likely to occur and be tolerated by the public at large. It doesn't, though, make the overreach right or legal. And if the courts were to permit this approach, it will have long-term and undemocratic consequences well beyond this one unpopular litigant. So it's essential, in my view, for the Court of Appeal in this case to clarify the legal limits on the statutory discretion provided by these commencement provisions. So I hope I've explained that case well. It's a really interesting case, well beyond the obviously juicy controversy about the case. This constitutional issue and the long-term implications of interpreting commencement provisions this way are actually so much more important. And I wish that this part of the case was what was receiving attention. And in fact, I agree with the college, and that's why we are intervening in support of their position that the executive didn't have the authority to do this. It's open to the legislature to go back and amend the law, but if they got cold feet because they caused a big controversy, but they can't do what they did in this case, and I think Canada Christian College is right about that. So that's the case. It's going to be argued on June 14th at the Ontario Court of Appeal, and as I said, we're going to be intervening to make arguments about parliamentary supremacy and some of these really important principles. If you want to stay up to date about this case and about our other ongoing cases about constitutional law, you can sign up for our freedom updates at the ccf.ca/freedom updates. You can also support our litigation by making a tax-deductible charitable donation at the ccf.ca/donate. And of course, share this video with your friends and family if you think that they would find it interesting. And don't forget to like and subscribe and to ring the notification bell so you never miss one of our updates. Okay, that's all for today. Thanks for watching, and let's keep fighting for freedom in Canada.